welcome along. I'm Chris Sutton, and this is Simon Fenton of Fenton Elliott Solicitors. I thought it'd be really useful for us to talk about some issues that crop up a lot in employment law. And in particular, I thought it'd be really fun to ask you, Simon, a few questions about some of the most interesting matters you've dealt with and some of the worst questions you've been asked.
Yeah. So this comes under the heading, I think, of hindsight is a wonderful thing. Call us before you need it. I have. This is not uncommon to get a phone call saying something like, "Well, I've done this. That's all right, isn't it?" And you go, "Well, no, it's not all right." And if you'd called us beforehand and said, "Should I do this?" I could have nudged you in a different direction, and we wouldn't really be having this conversation. Quite a memorable one was a chap who called me in January and said, I've got a really unhappy bloke. I had a word with him on Christmas Eve. I let him know that we were going to have to make him redundant, and he shouldn't come back after Christmas.
Oh my goodness!
And tell me about how you let him know. And he said, "Well, I went up to his workstation. I tapped him on the shoulder. I leant over. I didn't want everybody to hear, and said, 'Listen, Terry, I'm going to have to make you redundant. I know you've been here 20 years, and I like you, but I'm going to have to make you redundant. Don't come back after Christmas.'"
Wow! Merry Christmas.
Merry Christmas. And but that was all right, wasn't it? I did warn him. And a lot of employment law is about process. Right, employment relationships come to an end. People don't always do what you want in the way you want them to do it. Sometimes it's irretrievable breakdown. But what an employment tribunal will look at, generally speaking, is whether you've fairly tried to resolve the issues, whether you've been through a fair redundancy process, grievance process, disciplinary process, any kind of process where the idea is you address the concern with the employee, you haven't taken opportunity to try and resolve it, and then if that doesn't work, then you can legitimately dismiss somebody with or without notice, depending on the circumstances, and that's how it works. And then if they're not happy about it, they can take legal advice and maybe take you to an employment tribunal if they're really not happy about it and they think you did it wrong. But if you follow the right process, and it's properly documented, when that employee who has now not got a job, for example, rocks up to see their lawyer and they say, "This is what happened," as the employer's legal advisor, I want to know that when the employee then takes legal advice, the legal advice will be, it looks like they did the right thing in the right way. By all means, we can sue them, but I'm not doing it on a no-win, no-fee agreement because I don't think you're going to win. It'll cost you tens of thousands of pounds to do it, and I think you'll lose. But that's your choice as an employee, right? Your choice. You instruct a lawyer to do what you want them to do. And if you want to do it based on the information that is not a goer, up to you.
So I'm hearing two things here. One, it's important to have processes in place. So taking advice about your processes before you need to use them is important. And two, sense checking what you're thinking about doing before you actually do it.
Well, this very morning, before we're doing this, I had a call from a client who's got somebody who's an events coordinator. They've been employed for 6 weeks. The events coordinator, after she started work, disclosed that she is neurodivergent and finds events really stressful.
Oh,
yeah.
That seems a problem for their line of work.
That's kind of a problem, and doesn't take criticism well. Brilliant. So they're very aware that neurodivergence, dyslexia, ADHD are potentially disabilities. They're very aware that this gives an employee extra protection, but they've got an employee who can't do the job, and there doesn't appear to be, because they've explored this, any reasonable adjustment which will allow the employee to do the job to the standard that they need it done. So rather than just, and they have followed the rules, right? They've followed the processes. They've been in touch with us the whole time. We've been encouraging them to do the right thing. They would have done it anyway, I'm sure, because they're very switched on, but they're just checking with us. And the question is, if we do this, are we on solid ground? Are we going to get sued for it? The answer is I can't guarantee you won't get sued, but you're less likely to get sued if you do the right thing in the right way.
The key is taking advice at the right time. I see it in a family law circumstance all the time. People taking action and then taking advice afterwards going, well, was that okay?
Yeah.
Well, it doesn't matter if it was okay. It's done. And this is the same sort of situation.
Look, it's human nature, isn't it? I did this. That didn't go as I expected. That was the right thing. Was that the right thing to do? Maybe I should take advice. I mean, I'm sure we've all done it. But I think the more experienced you are at dealing with employment law issues, for example, the more you understand when the right time to just seek that advice. So we do have an HR retainer service where you can call us as often as you like, whenever you like, about any kind of employment law stuff. And we will answer your queries by phone or by email or in face-to-face meetings, unlimited, because one of the concerns people have, not unreasonably, about taking advice is, well, I don't know how much that'll cost. That'll cost a fortune. Lawyers are really expensive. And that anxiety prevents people taking advice sometimes when they should take advice. And it's only after they realise that they've got a big problem that advice becomes worth it. So if you kind of subscribe to the retainer service, then you just call us whenever you need, and you can just, whenever it is. And honestly, probably more than half the time when people call and say, look, we're thinking of doing this, is that all right? The answer is, yeah, that's fine. Crack on. And every now and then the answer is, whoa, just time out here. Tell me more about that. Yeah, no, don't do that.
But that peace of mind for employers can be really useful.
Well, it means that you don't worry about employing people, right? You never, because the retainer also includes employment tribunal insurance. So all of a sudden, every employee you hire isn't a potential bundle of issues and problems. They're just an employee. And and we can work out how best to get the most out of them, to train them. That's not really what we do, to train them. But if it doesn't work out, how to move them on. And then if that doesn't go as well as they'd hoped, they're insured against being sued. So for a relatively modest cost, all of those problems go away.
So hindsight's a perfect thing, but you don't need hindsight if you've got Fenton Elliott's HR Shield service. Yes,
exactly.
Perfect.
Exactly.
So if you are an employer who thinks you might be able to benefit from a retainer service, retaining the services of Simon and the team, please reach out at Fenton Elliott Solicitors.